Okay, we're going to open it up to some audience questions. I'm going to ask one more, and then we'll open it up. First Amendment issues. Kyle McClaro had a speech where he touched on some of the First Amendment concerns associated with net neutrality regulation. Are those concerns well-founded? Which way do they cut? I think the folks have used the First Amendment on both sides of this debate. Who has the better side of that argument? Gigi loves the First Amendment.
Well, I mean, look, even if you consider ISPs speakers, which I don't, I mean, what do ISPs have to say? Okay, and how is this? Nobody is saying they can carry whatever they want. We're just saying you can't degrade or block other people's speech. And I think that's the most important point, is that, you know, in areas of media, the Turner case and other cases, it's all been about balancing the interests of speakers, of the corporate speaker, okay, I'm not ready to concede they're speakers, and the public, all right? And the Supreme Court has upheld and other courts have upheld restrictions, for example, restriction on ILEX doing electronic publishing, all right, in order to promote speech, in order to limit market power. So again, it's the same feeling I have with regard to the takings clause. It's just like, I'll see you in court. I just don't see any precedent that would support saying that citizens don't have any rights vis-a-vis an ISP as far as the First Amendment is concerned. It's always been a balance of rights between the citizen and the media speaker.
I mean, I guess the one thing I would say on that is, and I think Gigi is right, you don't want to overgeneralize in terms of what it is at issue here, but I think courts, and if it got to it, the Supreme Court would be very concerned about the regulation of a forum, public forum like the internet, and would take very seriously First Amendment issues. And the other thing I would say is that in terms of the exercise of ancillary jurisdiction, or whatever jurisdiction they are propounding, I think the constitutional issues could come into play, because any doubt that those issues create, I think, is going to further undermine the FCC's case for exercising jurisdiction in a court's eyes.
Can I make one other point? Because if net neutrality is a First Amendment issue, I think again, those that, you know, it's interesting that Kyle would, you know, make this argument, because if that argument would win for net neutrality, it certainly would win for interconnection, right? I mean, wouldn't it also be forced speech to make Link's company, Link has left, Link's company interconnect with Comcast VoIP service?
Well, may I defend Mr. McClaro for just one moment?
I like Kyle, by the way.
No,
it's not personal.
No, I know it's not. He was responding to something in the notice of proposed rulemaking that suggested that the First Amendment could be an affirmative basis for adopting net neutrality regulations. His point was, and I think this is pretty indisputable if you refresh your recollection of the text of the First Amendment and where exactly in the Constitution it appears in the Bill of Rights, that the First Amendment is a limitation on government. It protects people from the government. It does not empower the government to regulate. It's not an affirmative source of authority to adopt regulation. So the context of his comment, I think, is important. I think First Amendment questions are implicated in the proceeding. That's a different matter. But his point was we shouldn't be using the First Amendment as a basis for regulation. First Amendment protects people. It does not empower the government to regulate.
With that, Barbara Espin looks like she has a question in the back.
Barbara Espin, Progress and Freedom Foundation. I have I don't know if it's a theoretical or a philosophical question that either Greg or Helgi or Gigi could answer, I hope. And that is, on reclassification of broadband internet access service as something else, the common carriage, is that action a policy action on the part of the FCC? In other words, is that a policy change that they can make if they can justify it on an adequate record? Or would it be more akin to an involuntary imposition of common carrier status on a non-common carrier? I think the answer could be different depending on how that action is viewed, and I'd be interested in your thought.
I mean, to me, it's an interpretation of its organic statute. I mean, that to me is that a policy decision? I don't know, but that's, you know, the FCC interprets the Communications Act. That's what it does, and as long as it gives, under Chevron, gives a reasoned decision for doing so, the courts will uphold it. If it doesn't, if it does things in a slapdash way, as some have accused the previous FCC of doing, then it will be overturned.
Well, I mean, I guess just to follow up on that just briefly. I mean, I do think that if you're the entities that is being labeled a common carrier and then suddenly subject to all these additional regulations, I mean, you're much more likely to view it as in the latter box than the former box, and that does raise legal issues and potentially takings issues. But I mean, I think Gigi's right that ultimately it's going to get back to whether the agency's interpretation can be defended.
We got a question from Scott Cleveland over here in the corner.
Yes, Scott Cleveland, Net Competition, and I have a question about competition.
We're hoping to get you a microphone here, Scott. I apologize. We want to make sure you get fully captured in the record of the today's
Cleveland, Net
proceedings.
Competition, have a question on competition. And Gigi, you mentioned that if the FCC was going to go back, one of the prongs they would have to say is they'd have to have a reasoned explanation that there isn't competition, that it didn't work. My question is a simple one, is when the court, if they got that coming back to them, wouldn't they have to define what competition is? And would they define competition for the first time in the context of the 96 Act, which promoted competition, or would they look to some other thing like antitrust? Because my question is the 96 Act was ending a monopoly policy and promoting competition. And I think it's indisputable that competition, or it's indisputable, it's no longer a monopoly. And so the question simply is, on what legal basis and how would the court, appeals court, define competition?
Well, again, the question before a court would be, was the FCC's judgment reasonable? Okay, so it's not up to the court to define competition, although some in the D.C. Circuit might feel otherwise. It's just that the FCC would have to give a reasonable definition of competition. I don't think this FCC would define competition as more than one, as two, as opposed to one. Yes, we're not in a monopoly world. We're in a duopoly world, although we are in a termination monopoly world, which we don't talk about. So, so let me talk about it for a minute. So I sell Gigi water, okay, and I've got a website that I want everybody to see, but my Brian's ISP, which is we'll call AT&T for now, okay? They have a favorable deal, because I don't think there's any AT&T representatives in the room. They have a favorable deal with Fiji Water, okay? Well, if I want Brian to buy Gigi Water, I'm screwed, okay? Because Fiji Water's website comes up a lot faster than Gigi Water's website. So there is a monopoly problem here. It's not, it's not the facilities-based monopoly, that we have facilities-based duopoly, but we still have a termination monopoly. And I would think that the FCC would consider that termination monopoly in making any decision about whether there's competition or not.
Indeed, that was part of the NPRM, as I recall.
Yep.
Additional questions? Yes.
Two questions, perhaps quick ones. First, would it be the FCC's position that they have taken the third way? In other words, that the NPRM is, in fact, without prescinding from whether or not it is satisfactory or not, would it be their position that, yes, they did follow the third way in the NPRM? First question. And the second one is also on competition, but competition between agencies. Does anybody see a role, or how would you characterize the proper responsibilities of the Federal Trade Commission here with regard to the Internet? They certainly have gotten involved in behavioral advertising and other issues that certainly trench on Internet questions and possible FCC authority.
I can answer the first question. I would think, I don't want, if there's any FCC people in the room, they can stand up. But I would think the answer to that is no, because in the NPRM, they relied on the same policy provisions, 230 and 706, that they relied on in the Comcast order that's currently the subject of the appeal. So if the D.C. Circuit says policy provisions are not statutorily mandated responsibilities, you have to have a substantive regulatory provision of the Act that you're relying on, they would have to redo. So the NPRM did not attempt to do that.
I thought it was slightly broader than what they relied on the Comcast.
They threw in
order.
a couple other things, but
I mean,
wasn't terribly
I think
serious
they would argue they've done
effort.
it the correct way, I guess.
Yeah.
I
would
would-
you?
yeah.
Okay.
I
Well,
think they
that's-
would argue that they